So, friends, first of all, I welcome you on the panel discussion in respect of important development in transfer pricing for intangibles. We at ICI, we are trying to see this that member get updates and best of best faculty interact with them. The technology has made so much advancement. As such, the people are sitting in different location. They can feel that they are talking in front of each one. And as such, today, I am sitting in Rajendra Place. SP Singh ji is sitting in his house. Vashne sir is sitting in the office. I can see beautiful sofa is on the back. Srivastava sir is also, I think, is in home. Yeah, Vinash is in office, and Mohit is also in office. So I'm thankful to each one of you for giving us the time to ICI. And today, the flow of the program will be on intangible like this. SP sir will be moderating the entire program. Kamlesh sir will give some of the keynote address and the problems, if we could stay for the longer time, the problems which the members are facing or the stakeholders are facing, if they can be pointed out. So Kamlesh sir will look into, and GC Srivastava sir will be over looking to the all young panelists, our CA Avinash Gupta, past chairman of NIRC, and CA Mohit Gupta ji, one of the dynamic new entrant, and then it will be concluded by question answer. I always have an endeavor that the question answer must be given, because without that we will not be able to hold our participant for a longer time. So with this, not taking much of the time, I'm once again very honored that Vashne sir has come here, and today I still remember 1989 when I appeared before him in a small case, and thereafter he has been in regular touch with us, and the institute always looked towards him as one of his friend, guide, and philosopher. Whenever we have a difficulty, we always go freely to it. Thank you very much. Over to SP6 sir.
Thank you, Sanjay ji. And we are really very fortunate to have Sri GC Srivastava sir, a doyen on international taxation and guru of all of us present today in the panel, to be with us. And he will be sharing his thoughts on several of the issues. Special thanks to Mohit and Avinash for preparing the whole discussion point. Before I talk about the issues or the topic which we will be discussing, I will say a few words about Kamlesh. I mean, though he's a person who does not need any introduction. I don't think that any practitioner, any chartered accountant who is practicing in taxation would not be knowing about Kamlesh. It's not because he is occupying a seat of power. It is because he is a person who is genuinely interested in international taxation, who is humble to the core, and who is always ready to share whatever information, wisdom, and experience he has got. He is open to suggestions. There are many feathers in his cap. If I start, enlisting them, I think there will be hardly any time left for the discussion. So I will not go into that. Kamlesh, most welcome. And we all have been very eagerly waiting for your participation, your work which you have done in various international fora on behalf of India shows the extent of knowledge, clarity of thoughts, and vision of in the area of international taxation. Friends, as Sanjay ji rightly said, today is a topic which is going to be very, very important in the years to come. And this is because if you look at the way technology is improving, and not only improving, any technology which is developed today becomes part of our life in the shortest period ever seen by the human being. Almost all aspects of our lives are being affected by technological advancements. And as has been said by Sanjay ji, sitting in different places, we are able to participate in a discussion in a very, very lucid, very, very intimate manner. And this is only because of technology. The times to come, we'll see emergence of because of the rollout of 5G, artificial intelligence, robotics, Internet of Things. These are the things: blockchain, 3D printing, genetic engineering, quantum computing, just to name a few, which are going to impact the lives of all of us. It is estimated that 84% of the total market value of S&P 500 companies are because of the intangible assets. And in respect of the Nasdaq company, the total value of the assets which they have, intangible constitute as high as 95%. So you can imagine the extent to which intangibles are dominating. If you look at the companies which are, the top as per S&P or any agencies compilation of data, the technology-driven companies are occupying the top 10 positions. Now, when we say this, at the same time, the convenience with which these transactions can be undertaken within the group and outside the group. When it is taken within the group, it creates more problem, not only from the perspective of taxation, but more so from the perspective of transfer pricing. It is a possibility that a payment from a resident to a non-resident may not be taxable in India because of various reasons. But it cannot avoid transfer pricing. The amount which is fixed as set off of the expenses are going to be seen by the tax authorities from the perspective of transfer pricing. So transfer pricing becomes very, very important. There are many aspects in relation to transfer pricing which are really bothering everybody. First is non-availability of exact comparable. How to do that? We know that the transactions of intangibles are not very common transactions. You do not find every day in the market. Now, this being the situation, how to go ahead and evaluate the intangible, how to do these things are actually bothering everyone. There are almost all the countries across the globe are concerned about the transfer pricing aspect of the intangibles. Action Plan 8 is devoted to that. The OECD has modified Chapter 6 in light of the developments in the area of intangibles, hard to value intangible, different types of intangibles, how to value them. But no organization is going to tell us how to value it in a particular situation. It has to be done by us. It has to be reviewed by us. All the stakeholders have to pull their socks up to understand intangible, to understand the valuation of intangible, and to implement the concepts of intangibles. This is why today's webcast is very important, not only for those who are well versed in transfer pricing and aspects of international taxation, but more so in respect of the young members of the ICAI, because they are going to be there for in the years when these intangible questions are going to dominate compared to any other transaction. Intangibles are going to constitute a smaller portion compared to intangibles. So friends, I will request you not only to listen to this webcast very patiently and carefully, But whenever you find time, do that. Try to learn as much as possible from the discussion which the learned friends with me are going to undertake. With this, I will request Kamlesh uh, to open the whole discussion which with his thoughts as the keynote address. Over to you, Kamlesh.
Uh, Thank you, sir. And thank you, everyone. Thank you, ICAI. Sanjay Agarwal has been a long friend. Only thing he got the year wrong. It is not 1989 because, I was posted in Delhi only 1993. So it must have been after
83.
that.
Yeah.
But has been a very useful interaction with him at that point of time before I proceeded on my foreign deputation. And we both used to learn from each other. And good to see that Sanjay is, achieved so much in his career. And really grateful to Institute of Chartered Accountant, who is always willing to provide a platform for learning of its members. And it also gives us an opportunity to learn from each other. So thank you very much. The topic today that has been chosen is really a very pertinent topic. Why? Because in brief, this has already been touched upon by Sanjay and SP sir. So basically, we know that over several decades, this globalization of economy has happened, and trade has grown exponentially. Digital transactions have increased, and because of that, there is larger role for intangible to play in transfer pricing. And one thing about intangible was that it is really mobile. So what used to happen, most of the MNCs, they used to develop intangible at a particular place of location, and then they used to transfer it to the tax haven. US was the country which was maximum impacted by this development, as we saw that most of the MNCs, digital having doing digital transactions and based in USA, hardly used to pay any tax in USA as well as in other country, because the way they used to structure their transactions, that intangible always used to rest with the tax haven, where they didn't have to pay any tax, and all the profit used to be parked in that tax haven. So that was the position at that point of time, and probably that necessitated OECD also to have a look at how to do transfer pricing with respect to intangibles. Normally, when we talk about OECD principle, we all used to think about source-based principle or residence-based principle, and there was always a tug of war between developing country and developed country because their interest was clearly demarcated. But with this kind of development, first time countries realize that nobody's getting any tax and something needs to be done, and that is how BEF project started in 2012. And in 2015, we had BEF's report on various action points other than action point 1, that we all know that that report is still pending. So the 2015 reports, we had action point 8 to 10, which had revised guidance with respect to issue of intangible. And the OECD tried to ensure that the transfer pricing rule secure outcomes that see operational profits allocated to the economic activity where they are carried out. And one good thing about this particular BEPS report is that non-OECD countries also participated on equal footing, and that means India also participated in that deliberation, and India also signed on those documents. So while we say that OECD documents, OECD commentaries are not binding on us, but this particular BEPS report, which changed the OECD guidance on transfer pricing, is binding on us because we have signed on it. So some of the very substantial changes and very impactful changes, I must say, were carried out through these action point 8 to 10. Although a lot of writers have written on BEPS report so far that only incremental changes have taken place. But I think if some good changes have taken place, it is in this area of intangible benchmarking that action point 8 to 10 has come out with, which has in consequence have made changes to chapter 6 of TP transfer pricing guidelines of OECD. So first major change was that conduct is not important. Conduct is more important than contractual arrangement, because what used to happen by this time was that all transfer pricing was carried out based on contractual relationship between two parties. Now that contractual relationship can always be subject to manipulation. One can always assign a higher role to a party which is located in tax haven, while the actual operation is being carried out somewhere else. So this was one of the major grievances of all countries, that conduct should have better recognition than contractual arrangement. So that was recognized in action point 8 to 10. Then the second important change in that guidance was that if an arrangement lacks commercial rationale, then one can disregard that arrangement. So that was also very important. The most important change was with respect to the risk. We all know that the transfer pricing benchmarking, particularly with respect to the intangible, always gives more reward to the person who is undertaking risk. Now that risk was once again based on contractual document, was always residing with the associated enterprise who is located in tax haven. It doesn't matter whether that associated enterprise had the capability to take that risk. So the major change that took place in this action point 8 to 10 was that OECD recognized that risk contractually assumed by a party which cannot actually control the risk or does not have the financial capacity to undertake that risk will not be rewarded for the risk. Actually, who is the party who is controlling that risk, who has the financial capacity to undertake that risk, would be rewarded. In fact, it's not right for me to take a name of a particular case, but in India also, we had a case where ITAT ruled in favor of the taxpayer, and that was by the time these guidance note had not come. Now, in that case, the intangible was developed in India and was transferred to British Virgin Island. And but later on, that intangible was challenged in United States, and it is the Indian entity which had the capacity to defend all the cases in United States. So that means it is the Indian entity which had the capability to control that risk or financial capacity to assume that risk. Now, those factors are very relevant to determine which entity should get compensation for the risk. Another important development that took place was that the legal owner alone is not necessarily the one who should get the return from exploitation of the intangible. So DEMPE function, we know, this is acronym for development, enhancement, maintenance, protection, and exploitation. So the party which is doing these activities should get reward for development, enhancement, maintenance, protection, or exploitation. Now, there are practical issues associated with it, and I'm sure that is going to get covered in the presentation or panel discussion later on. But the main point here, once again, is who controls it. We had circular number 6 in 2013 in respect to contract R&D service provider. So a common question is that we have back office IT service provider, and they are also doing contract R&D functions. So can we say they are developing intangible? Can we say they are enhancing intangible? So should they be rewarded for that particular function? So I think we probably need to, also discuss these points, because practically they are very important points. Circular number 6 clearly said that if you are not taking the risk, if you don't have the control over the risk, then you will only get arm's length compensation based on normal TNMM, whatever benchmarking we do. And that was also repeated by OECD in their Action Point 8 to 10 report, that once again, who is controlling those functions? So if I am a contract R&D service provider, whether I am controlling what I'm supposed to do, or there is somebody else sitting on top of me in some other jurisdiction who is controlling what I'm doing. Now, these are factual determination. Many times on paper, you will see that it will be written that the entity which is in the other country who is controlling me, and therefore I am not developing that intangible. If that fact is correct, absolutely right. That's a correct determination. But we also have to be careful whether that fact is correct or not. I think, once again, because it is transfer pricing, so delineation of transaction, fact determination assumes a lot of importance. And why I'm saying this is because, this is one area where if intangibles are located in India, we all will benefit. India will benefit, revenue will benefit, and you tax professionals will also benefit. Because if intangibles are located in India, there will be more economic activity, there will be more tax-related activities. So it is important that we do recognize the fact situation properly and make sure that wherever compensation is due to India, we should get that compensation. And once again, I'm not saying if it is not due, if we are doing only back office contract R&D and are being controlled by somebody from outside, then of course, whatever we are getting as cost plus is adequate. There is no dispute on that. But probably it is a time that facts are properly recognized so that we get our due share of taxes. So this is all I have to say, and surely we'll be eager to hear from SP Singh sir and GC Srivastava sir and other panelists, Avinash and Mohit. Singh sir and Srivastava sir have always been our guide in the department, and everybody look forward to them. So to the extent I am not called by somebody in the department, I will try to be here and listen to them. Thank you so much.
Thank you, Kamlesh. So nicely, you have summed up all the important aspects related to transfer pricing of intangibles. I totally agree with you that if the Indian entity is conducting the functions, is using the assets and is undertaking risk, then in that case, the rewards should not only on the cost plus basis, but should be much more than that. One of the reasons, and JC sir will add to that or make any amendment to that, is that one of the issues which has been causing problem for the the companies to have the IP registered in India is because of our IP protection laws. It's a very interesting thing to say is that the Parliamentary Standing Committee on Commerce, they said that a mere 1% improvement in copyright protection increases foreign direct investment by 6.8%. So we as a country, I think we need to strengthen our the laws around that. But that is aside. It's not to say that India should not get the reward, but should get reward as any entity who will be conducting the functions, assets, and risk should be rewarded accordingly. Thanks a lot, Kamlesh, and I think we should go and dive into that. Before that, JC sir, will you like to say anything on?
I think we are on a very interesting stage. Let those presentations start, and we'll keep on discussing as different aspects as and when these come.
Thank you.
Otherwise, picking up at one stage and then.
Thank you, sir. Thank you. Vikas, can you put the panelists? Let me thank all three panelists. In fact, JC sir is our special invitees. Mohit and Avinash are the core, panel members. And just to give you a brief introduction about GC sir, I think most of you would be knowing he has been, as Kamlesh rightly said, in the department, everybody looked towards him for guidance in the area of international taxation. The clarity with which he speaks, you all will be hearing that. His experience is tremendous. Right from the day one when the international taxation started in the department in a structured manner, he has been at the base and has been contributing. Avinash has a lot of experience. He is among the, medal winners. Among the CA final examination. He is a law graduate as well, and he has done his LLM in international taxation from Vienna University, Austria. And he has authored 3 books on international taxation and transfer pricing. He has been elected, and he has been very, very active in the area of, or in the Institute of Chartered Accountants, contributing in various ways. Being the member of, as member, as well as being a speaker. I think he has more than 1,500 lectures in different forums. In the tax department, as well as ICAI and other organizations. We are fortunate to have Mohit, who has more than 15 years of post-qualification experience and expertise in consulting clients across the direct taxes. And he was at various consulting firms among the big fours. And he is fully geared up to talk about the intangibles, because he has hands-on experience about the intangibles, the way the transfer pricing of intangibles are done. So, friends, we have the 3 panel members, experts in the area of transfer pricing. With this, let's start our presentation.
SP sir, can I take
Yes,
leave,
sir.
because there
Sure,
is some work which is given by President. I have to complete.
Sure.
Thank you,
Sure,
sir.
sure, sir.
Thanks, everyone.
Thank you.
I'll join after some time also.
Okay. Anytime you feel like.
Thank you.
When Kamlesh was talking about one thing which he mentioned, and when the slide comes up, you can see that because the international organizations have been really worried about the strength of multinationals to evade taxes through various means, and they have been trying to ensure that this base erosion by shifting of the profit is minimized, and that the result of that exercise has been in the form of BEPS, and 15 action plans have been put together by the OECD, and the entire structure, all the 15 action plans are structured around 3 basic concepts, which are substance, transparency, coherence. And transparency means sharing of information by the taxpayers with the tax department, and substance is the one which is emphasized in various action plans. There has to be a substance in any transaction before it can claim any benefit. So India, being a member of G20 and being invited in the OECD, is very much in the thick of the developments of the OECD action plans and the subsequent actions whether pillar 1, pillar 2, and the things which are going. And you will, all my friends will be very happy to know that ICAI has been taking very active role in giving the views to the OECD in respect of opportunities which are, or the views which are sought by the OECD. So with this, I pass the baton on to Mohit to take forward the discussion. Over to you, Mohit.
Thank you, Singh sir, for such a generous introduction and setting the context right. So now let us start with today's topic. So guys, this slide talks about what are we going to discuss during the whole session. So this is just a bird eye view. What are we going to discuss during the session? So let me start. First of all, we are going to discuss what are intangibles. That's the crux. Then we are going to talk about what are the 6 steps framework which OECD has provided, how to benchmark these intangibles. Then the concept of legal ownership versus commercial ownership, and then the DEMPE analysis. Then the next one would be challenges while determining the arm's length price. What are the major challenges we face when we determine the arm's length price for the intangibles? And then we'll just touch upon how to value intangibles. Okay, so let me start with the most fundamental question: what are intangibles? So the guidelines has given, there is no specific definition for intangibles. Okay, so what we have to understand is, let me give an example of intangibles. Intangibles are like trademarks or brand name or patent or any other which does not have any physical existence, or they do not have any these cannot be considered as a financial assets. Second aspect is they can be owned or controlled for commercial activities. Third one is they can be transferred and would be compensated in a transaction between third parties. This is the basic definition provided in the Chapter 6 of OECD. The Indian Income Tax Act, when we talk about Section 92B, they have amended this. They have introduced this concept of intangible property from Finance Act 2012, when they have extended the definition of Section 92B. So there they have given 11 to 12 points which should be included. What could be the flavor of intangibles? So there were a few categories. The main one I have documented here. The first one would be marketable intangibles. So trademarks, trade names, brand and logos are covered under the head marketable intangibles. Then the next one would be technology intangibles. Technology is know-how, patents, processes, blueprints, etc., etc. Then the third category is artistic intangibles. Artistic intangibles, if I have to give an example, like literary works, copyrights, musical compositions, etc. Then the next category is data processing intangibles, which comprises of proprietary computer, software copyrights. Engineering intangibles would include design, blueprints, trade secrets. Then next category is customer-related intangibles. So in customer-related intangibles are customer list, customer contracts or agreements, which is again something you most are not aware of. Then the next category is contract-related intangibles like license agreements, franchises agreements. So a lot of multinationals, they work in different jurisdictions. So they sublet their licenses and they have the franchise agreements in place. So this is also a very important aspect of intangibles. Then comes the human capital. Coming from a service background, so we know the importance of human capital. So the trade workforce employment agreements with trade unions come under this category of intangibles. So I hope we got a flavor what intangibles exactly are. So.
Can I add something here?
Yes, please, Avinash.
So friends, what is the importance of the topic is that we know that for a tangible property, there is a value attached to it. But with the growing globalization and with the growing IT in place, so there is a great amount of value which are attached to something which is not tangible. So Mohit is trying to give you that flavor that in the initial definition with OECD have said that there is a value which needs to be appropriate assigned to something which is not an physical asset which we can touch upon. So there are different categories of intangible. What Mohit have just mentioned is 4-5 types of intangibles. So let's take an example of one, which is simply a franchisee agreement. So we all know that what is a franchisee. So somebody is there whose name is big and he has just given a franchise. So let's take a simple example that there is a Haldiram restaurant that I am running, which is a franchisee of main Haldiram. What I am doing there is I am also selling some items there. So assume if I am selling those items without the brand name of Haldiram and with the brand name of Haldiram. So does you feel or don't you feel that in the eyes of the customers, whether it makes any difference? If answer is yes, it means that yes, even merely a franchisee of a branded product will create some kind of a value in the organization. And it also gives some kind of an ability to that organization to earn some profits. So in those cases, if they are getting some value for this intangible, which is coming out of a franchisee, then the person who is the owner, then we'll discuss legal owner versus the economic owner, then he should be compensated for the same. And if he is compensating, then this needs to be benchmarked. So this is the whole thing what we are going to discuss in next 2 hours or 1.5 hours about the intangible and how to value it. So that is what in simple language we can say about these intangibles. Over to Mohit.
Thank you.
Just Mohit, can I add one thing? On this 92B2, which you have listed, only one clarification that this software copyright in India, it is recorded as a literary work under the Indian Copyright Act. So though it may be a data processing intangible, but yes, legally that is a recognition it gets. It is under the Indian Copyright Act. Yeah, that's all. I mean, later on we'll come to this point possibly.
Definitely. So guys, we have covered what are we going to discuss? What are intangibles? Now let's move ahead. So this is just an introduction, like what we have covered earlier. This is basically what should be covered under the umbrella of intangibles and what should be not. Like I have previously mentioned, financial assets or tangible assets cannot be covered under the category of intangibles. They need to be, there has to be some commercial activities behind intangibles. It should be compensated between the independent parties, capable of being owned or controlled. Like see, the key aspect here is the control. Who owns the control? Whether these intangibles can be controlled or not. Okay, and what should not be considered as intangibles need not be an intangible for accounting purposes, need not be legally protected, need not be separately benchmarked. So these are the few distinguished elements between intangible and tangible category. Okay.
So Mohit, let me add something here. If you go back to the earlier slide, so this is very important. I mean, and we should always remember that it is not necessary that an intangible should be in the account for the accounting purposes as well as for the transfer pricing purposes. There can be several types of intangibles which Mohit has shared with us in the list, which are not there in the accounting purposes. So there, when you look at the valuation of intangibles or accounting for the intangibles, it is possible that as per the accounting principles, they will not be present. They have not to be accounted for when you prepare your balance sheet and profit and balance sheet. So that has to be kept in mind. So for when you talk about the human intangible and other type of intangibles, you won't be you won't be showing that in the balance sheet of any company. But when the transaction of the company is undertaken, then in that case, these are the elements which become very important. And I will like to ask Avinash to just give his reaction on this statement.
I think, sir, you're absolutely correct that there are many intangibles. So just give you an example to it. So customer list. So if my parent entity have provided me a prospective customers in the country India, so that list is being shared by my parent, or any reference coming is just being shared to me, and I as an Indian entity go meet them, sell my services or goods to them. So this is one intangible which I get, which is not recognized in my books of accounts as an accounting principle. Or maybe for an expat is being deputed to me either on a secondment basis, or my parent entity or my AE have identified some human resource for me which have been deployed on Indian entity, and Indian entity is paying the entire compensation, etc. So the process of deputing, the process of sending that person is also not recognized by the accounting treatment. But yes, there is an intangible which have been attached to it. Similarly, sometimes the intangibles are being given to the another group company of AE without having any kind of a legal ownership or legal structure being created. So it is not like that when somebody is giving you a use of a brand name, etc. But there are certain intangibles like experience, market experience, etc. So these are being transferred to within the group, to the AEs or within the group entities without any intention to create any kind of a legal commitment or legal requirements for that. So that's why I feel that intangibles can be created by any act, or they may be recorded in the financial books. They may be assigned some kind of a financial value. They may not be assigned. And moreover, they might not create any kind of a legal structure or legal binding on each other. So intangible is intangible. This is from my side.
Thank you. So should we move ahead? Are you guys with us?
Yes,
I think GC sir want to say something here. Sir, you are on mute, sir.
No, it's all right. I mean, clear. I mean, we can move.
Manash, you would like to take this up?
Oh, you please carry on. So this slides, I think, Mohit, what it talks about, it is a history. So if you read in 1975, what the companies or a bigger M&E groups, they have more of a tangible assets and less of the intangible asset. Over a period of time, if you see in 2018, and this is an S&P 500 companies report, which is there and published in 22, you see the value of intangible today in the entire globe have increased substantially. This is because of use of technology. This is because use of cross-country products, information flowing freely, and lot of kind of intangibles which is being created and recognized by various entities. So that shows a chart that how from 75 to 2018, the businesses are recognizing the value of intangibles in it. So in the next slide, if you Mohit, you move to the next slide, that just gives you a flavor of in 2019 edition, how the companies are being valued for their intangibles. So if you see, Microsoft is being valued, the intangibles in Microsoft is being valued at $904 billion. And this value is about 90% of the total value of the enterprise. So think of $1,000 billion company is being valued, and out of the $1,000, $900 relates to only intangible. What is the intangible of Microsoft? Is the software, the Windows software, the Office software, what you and me are using on a day in, day out basis, and then many other software. So how in 2019 edition, if you see that 90% of the value is coming from intangible. Similarly, in Amazon, there is a process intangible, there is a brand name of the company. So if we see in the today's world, so if once we go and shop on Amazon, we are doing it many times because of the brand. So in 2019, if you see, Amazon intangibles are being valued at $839 billion, which constitutes 93% of the total value. Apple, we all know it's a giant on the technology, specifically in the mobile and computers. 77% of the total value is ranging because of these intangibles attached to in it. Then we move to a company like Visa. So what is Visa is doing? They don't have anything physical asset, but everything is an information, the process and everything. And in 2019, Visa is valued because of 100% values coming from intangibles only. So with the changing scenario, the valuation of the companies are majority based on the intangibles which are involved to it. So that itself shows from a transfer pricing perspective, how important the subject is both for the revenue as well as for the assessee. Because every revenue, whether it is Indian Revenue Department or a foreign revenue department, everybody wants to take their fair share of revenue, which is tax on these intangibles, whether these intangibles are being transferred or sold, or they are just given a license to use. So just here, there are two important aspects what we need to cater in the next 1 hour. One is whenever there is an outright sale of the intangible. So for example, I have created some product, some other intangible, and I am selling it to some other entity or some other group entity or maybe other entity. So then what should be the consideration and whether the consideration is correct or not? So that is one answer. Or if it is not sold, then it is just given as a license. So that is also something which we need to take care, because now majority of companies are being valued because of these intangibles only. So over to Mohit, if you want to add anything here.
I think what Avinash has said, I just resonate the same. See, this is a globalized world. So like we mentioned earlier, companies like Ola, Uber, Amazon, all these companies are operating or they have intangibles parked in different jurisdictions, and they are exploiting markets in a less developed nations like India, where there is a huge market. So I think what Avinash has mentioned is quite right, that everybody should get a pie in the cake. It's not only the company. So that's why it's really important to understand the concept of intangibles and how it should be evaluated, what are the DEMP functions and how to do that. So I think the context set is really right. I hope you all are with us, and can we proceed further? GC sir, SP Singh sir, if you want to add anything.
Yes, please,
Okay.
please.
Thank you. So because the next topic is quite interesting one, because we are going to touch upon the steps provided by the guidelines to how to in the context of intangibles, how to really identify intangibles and how to really. So the first 2 points, GC sir, I would be needing your support here. So the first point talks about DEMP analysis of intangibles, how to identify intangibles. The second point is legal ownership, sir. So do you want to say something about the legal ownership?
See, in this analysis of these intangibles and DEMP functions and all that, two concepts emerged. One, legal ownership, and the other, economic ownership. Legal ownership, as we know in very simple terms, it's the person who owns that, legally who owns that IPR, that intellectual property. But the economic ownership is one who really gets the benefit of it and also takes up with it the risks associated with that benefit. So questions have arisen, and they have rightly arisen, that where the legal owner does not take any risk or does not contribute to the DEMP functions, then is he really entitled to the benefits arising out of that intangible? That's the question which has been hovering, and this legal ownership really gave them, the multinationals, the room to shift their profits or their income to different jurisdictions. And once that is curbed, and that now gets with these reports of OECD, now if it gets linked to DEMP functions, then obviously that legal ownership will lose its sheen, and that temptation to shift the scene. But one very interesting development which I saw in a couple of cases very recently, which I was arguing at various forums. Now, in relation to IPR, once I'm facing the argument there, and backed by several decisions of the high courts of Delhi, Kerala, Bombay, that where does the IPR reside? Where does the IPR is located? And is it located where it is developed, or it is located where it is exploited, or it is located where it is managed or controlled? So the question is arising that yes, it goes with the owner. I mean, that's an interesting, and if that be the legal position, then yes, it does raise quite an interesting issue, that if it goes with the legal owner, the location, because that would be very relevant in the matters of transaction of particularly capital gains, because capital gain is charged on the transfer of asset, a capital asset located in India for that matter. So but the point is that if that intangible has really been developed by one entity and it is owned by the other, then it's very correct to say, I mean, and that is the position now in Webb's report also, that the benefit should go according to that. So, but in understanding the concept of legal ownership, I would say it's a formal ownership in law. For example, a trademark may get registered in the name of X, though it may have been developed, maintained, protected by some other entity of the group. So that entity may be the legal owner, but not necessarily this economic ownership. And then linked with the economic ownership is also the concept of beneficial ownership, though a beneficial ownership is rather a narrower concept, but we'll come to that. So I think any doubts on this, well, we can discuss certainly. Yeah.
Mohit, there are 3 types of involvement we can classify on a very broad scale. I'm taking cue from JC sir. One is financial assistance, financial involvement. Other one is the functional involvement or risk involvement, asset involvement. So FAR involvement, you can say. And the third one is the legal involvement. So as JC sir and in fact Kamlesh also said in the beginning, it is possible that the product maybe or intangible may be registered in the name of XYZ, but that may not be involved in the financial contribution, or may not be involved in undertaking the functions, asset or risk for developing an intangible. There the question arises whether that would get any reward for that or not. So that has to be looked into, if or not, and if yes, to what extent it should get. If suppose, why I'm saying this, why I'm saying that it is possible that there may be something, is because if one takes the responsibility of being labeled as a legal owner and invites the cases or against it, then in that case it can say that I have taken certain risk and I should be compensated. That has to be kept in mind. The second one is the financial support. So if is it simply a form of investment? Should it be rewarded as the the bank rate basis or something like that? Because if the company has only put the money, has not been taking part in the development and the MP function, which Mohit will discuss in a few minutes, then in that case it should be rewarded only for the investment. But the company which is involved in the development and protection and MP functions will be the actual claimant. If there are more than one companies involved in that, then in that case that has to be the consideration received has to be distributed between the two in the ratio in which they are undertaking the function, asset and the risk. So this actually underlines the concept of the distribution of the consideration, and it goes along with the ownership aspect, not only legally but factually.
Yeah, I think I fully agree with you, yes. But the question is, it all will depend on the nature of that intangible. Because there are certain intangibles where financial contribution has some role to play, no doubt, in creating that infrastructure for development of that intangible. But the rest of it doesn't depend on that finance alone. For example, lots talked about, say, marketing intangibles. I mean, marketing intangible is one such example. I mean, financial aspect would be necessary, but to the extent of creating that infrastructure, that's all. But the rest of it, it's a lot more human efforts, lot more other creating the market is not only just sitting on a finance. I mean, you have a few crores of rupees and I can create the market. That's some bit of effort is needed. So development there is not only finance. So then in that event, what you said, should it be rewarded only on the basis of as an investment? Yes, depends on what kind of weightage one would like to give to each of these contributories to the development of that intangible. So it's a question of allotting that weightage.
Yes.
That percentage.
Sir, may I ask a question here?
Yeah, please. I mean,
So, sir, I just give you a situation. It's a purely hypothetical situation, but it happens and appears in many multinationals. So, for example, it's an US multinational having an physically presence controlling Indian markets situated in London, UK. They made an entity which is owning the IP, which is situated in a country like Netherlands or any other country, or maybe Cayman Island. Let's take a zero or low tax jurisdiction company at Cayman Island. And the actual software development or actual development of the intangibles is happening in India. So money is flowing from Cayman Island, for example, to India for development of that particular intangible, but it is physically controlled by people sitting in London. So that's generally happens. So when we say the financially, it is being financed by a Cayman Island entity, which is a part of the MNE group, but control is being situated in UK because the UK people are controlling the actual development, etc. Now, after the development, or maybe during the year that it was developed, then it was licensed back to another group entity in India on a royalty basis. And now we are testing or we are benchmarking that royalty, that whatever royalty is being paid. Here the question which comes to all of us, that whether that whatever we are paying as royalty to this Cayman Island or maybe Netherlands entity or any other entity, they are only finance the activity. I think if we can answer that particular case, so that will be very helpful to understand.
It's really not so easy to answer the point, but the point that you made is a very valid point, and you referred to, say, for example, development of software, for example.
Yes.
See, if you see, yes, there may be a control from some entity outside. It may be said that they are really having that vision or the conceptualization is there and they are supervising the functions that are being carried out in India. But let's not forget that who are the people employed in India? They are our computer software engineers who have that intelligence and capability to develop. Their role is not just, it cannot be compensated by just funds or by mere supervision. I mean, it's an intellectual input that is being provided. How should it be compensated? That's a different matter. How and what weightage we want to give and how we want to value that input. But that input is not of a mere some mechanical work. I mean, say of a software. And if you see, I had a chance in some of the cases to go through. When you see the actual registration of that particular software, if you go to the patent site where they are registered or to Indian site, I mean, you'll find the names of each of those Indian software engineers written there. And there may be just one American in that list of 20 people contributing. So that is an intellectual input. And where does it come from? Yes, you may assign, I mean, whatever value, I mean, we may like to give, but yes, I mean, it's not something very easy to answer, but yes, I would say that apart from that control and supervision, that factor has to be kept in mind.
Thank you, sir.
Thank you, sir. So I think that was very well articulated. So again, the first, if I talk about 6 steps, first step talks about identifying the intangible. Second step talks about identifying the legal ownership. These 2 points are already covered. Third, I think every transfer pricing expert gets excited when they hear the 3 letters. That is FAR. And in our trade parlance, we call them FAR. We call it a FAR analysis. So basically, FAR analysis means functions, assets, and risk. So DEMPI is nothing but an extension of FAR analysis. So we will discuss this once we proceed further. But just for a timing, I just want to give a flavor of what DEMPI is all about. Then the fourth point is having a consistency, like Kamlesh sir has already mentioned during his introduction speech. There has to be a harmony between contractual arrangement and the actual conduct. What he simply mentioned that there are we have seen live examples where the documents were generated way back in 2010 and 11. The company was simply a cost plus service provider, but now in India they have extended their functions, and now they are doing more value addition in the supply chain or in the entire value chain. So they should be remunerated extensively. But they used to say that, okay, we've been characterized as a cost plus, so we are still continuing with that. So this is a very important step, the fourth step which I'm talking about. There has to be harmony between contractual arrangement and the conduct. Lot many times client is also confused. They're like, sir, this is a legacy and we've been doing this. But when you go and discuss the FAR, when we have these functional analysis, or we send out the FAR questionnaires with the clients. So that time even they realized, if I take an example of software developer, so there is a whole cycle, or there is an entire chain. So there are functions like coding, there are functions like prototypes making, there are functions like testing. Who is involved? So earlier there is a possibility that the Indian entity is just involved with the routine functions, but now they are carrying out more significant functions in the entire value chain. So this is a very important point. Then the fifth one is recharacterization of the actual transaction. Again, this get back to the DEMPI analysis. We're going to discuss it in the subsequent slide. The sixth one is determining the arm's length price. This is what we do as a transfer pricing expert, determining the arm's length price. Okay, who should get what? The entire thing falls upon function, assets, and risk analysis. So I just want to highlight one thing. The revised OECD guidelines have highlighted that it's more beneficial to use methods like profit split method and a comparable and control price method when it comes to intangibles. We'll discuss why the cost-based methods like RPM or TNMM should not be used. So we will just talk about it in the next slide.
Yes, before we proceed further, I think if Kamlesh is there, I think it would be very useful to have his thoughts on this.
Sorry, sir, I missed that. Can you please repeat?
If Kamlesh is there, why not request him to give his thought?
Kamlesh, we were discussing this slide, slide number 8, about the DEMPI ownership and the compensation. So we're just wondering if you can give some view on this slide number 8.
No, this is what I had covered, that, we may have contractual obligation saying that this function is performed at one particular place, while other function is performed, more intensive functions are performed in overseas countries. And similarly, those things can be spoken about the risk. And that can be used to say that Indian entity is entitled to only cost plus compensation. But what I understand from DEMPI function is that we have to determine whether Indian entity is involved in development and maintenance of intangible or not. Now, how do we determine it? If I am only a cost plus entity, if I am only working under the direction of my overseas parent, then I am correctly compensated at cost plus. But if there is no such direction, it is a work has been given to me that Indian entity, you have to complete this work, and now how do outcome has been given? We want this outcome from you, Indian entity. No, it is now up to the Indian entity. How do they develop that particular part of intangible without any control from overseas entity? In that case, as per my view, these guidelines are very clear that Indian entity is involved in development and or enhancement of intangible and should be adequately compensated for that purpose also. So, I mean, in that situation, probably cost plus may not be enough. Maybe profit split. If profit split is not possible, then cost plus we need to have comparable who are undertaking similar R&D functions and see what are their profit margin. In the alternative. So this is my view on that.
Thank you. Yeah, Mohit.
Yes, sir. So this is the heart of the entire discussion, the DEMPE analysis. You must be wondering, we'll be talking about DEMPE. What exactly is it? So first, I just give you a background what this DEMPE thing is. Okay, I would say this is nothing new, but this is just an extension of FAR analysis. Like we do FAR, function, asset, and risk analysis to identify who is performing what functions, who is undertaking what risk, and what are the assets involved when we talk about the entire value chain. Okay, so in order to determine the remuneration for any particular function or an asset on a risk, we carry out a FAR analysis. But in case of intangibles, it is really important to understand this concept of DEMPE in the entire M&E. So there could be a situation that somebody is executing different functions, and there may be a chance where few entities are involved in development, or few entities taking care of enhancement, few is taking care of protection and exploitation. So let us start with this beautiful concept of DEMPE. So first of all, the first thing first is development. So we need to create an intangible. The intangible has to be developed first. For that, we will be needing some resources, be it human capital, funds, or know-how. So all these things. Like if I have to take an example of a software or let's say cell phone, in order to develop a cell phone, we will be needing so many things. So all that things in order to create an intangible, in order to create something new, comes under this category. So if I have to evaluate in the entire value chain, the development takes development being the most significant function, if I have to say. So it is one of the most critical functions, the development functions. Then enhancement. Enhancement means once the product is developed, you make innovations or you update that product. Okay, or you have to make some, let's say BMW. A BMW sold in Germany and a BMW sold in India would be different. So you have to make some tweaks to make it suitable for the market which you are dealing with. So that comes under the category of enhancement. So of course, once the BMW was being produced by or developed by the company X BMW, then whatever upgradations or enhancements being done in the entire thing, so that comes under the category of enhancement of intangibles. Maintenance, if I go by the definition, dictionary meaning of maintenance, it talks about keeping the things in a good condition. So maintenance could be a routine affair. So if you like to add on maintenance, please, you can add in between. So maintenance is like administrative or a routine affair. So once the product is developed, once the innovations are done, you're just maintaining it. Okay. Then protection. Protection is a very important function. It's like, for example, if you're having an Apple iPhone, so they have a major risk that it might get infringement or someone may steal this thing, the entire know-how or the design. So you need to protect your intangible. You need to protect your asset. So this is also a very important function when protection. Exploitation is all about linking it with the future benefits. Who is actually exploiting the asset? That's their key contention. So these are the 5 parameters. Whenever we talk about intangibles, we have to keep this in mind. Whenever we do FAR analysis for intangibles, these are the primary, you would say, the keystones or stepping stone to determine which entity in the entire value chain should be getting what based on this DEMPE analysis. So I will ask GC sir, SP Singh sir, you want to add anything on this, the DEMPE thing?
Yes. When we look at this, sorry, Avinash, you wanted to say something.
No, please, sir.
So when we look at these 5 words, DEMP enhancement, development, enhancement, maintenance, protection, exploitation, one thought comes in my mind. I need to think over it later on. That if you look at development, enhancement, and to some extent maintenance, it can happen within the group. It can happen within the organization. It can happen within the group. So far as the next 2 are concerned, we depend upon either some government agency or some third party. And why I'm saying this, therefore, development enhancement become very, very important. What is the meaning of development is the most crucial thing, particularly in respect of, so far it applies to all the intangibles, but if you look at the development of software, the development cannot happen within in one organization. It may involve, more than one organization. So what is development? And as rightly said by Kamlesh, GC sir, and you, Mohit, is that who has the control? Because at the end of the day, the product comes out, which is the core one, which gets into enhancement and other things. But how somebody is developing? Is it developing only through its own resources? Is it totally dependent upon some other? That will determine the compensation structure in respect of the developer. Yes, Mohit.
Yes, sir. So these, like we have already mentioned this, so so it's not necessary the AE or the one of the entities in the entire M&E who is just funding can claim that, okay, if I am providing funds, I should get the bigger pie in the entire share. So because those, like sir mentioned, who has control, or who the ultimate owner is that who has the control, who is running the show from behind. So these are the different parameters where we could actually understand which entity in the entire M&E in the entire group which is performing what. In case you are just performing funds, then you can be remunerated with the normal returns for just the funding function. So that's one of the key takeaways from this. Now I'll move ahead with again, this is a very interesting topic. So why we are discussing all these intangibles and what are the basic challenges faced by the M&E groups or the tax authorities when it comes to intangibles. So these are the 5 or 6 broad points. Okay, these are mentioned in OECD as well, where they have these are the bucket where we could see what are the basic challenges faced by the M&Es. So the first challenge would be that there is a lack of comparables available. So there could be a possibility that there is an arrangement in hand, but how to basically as we all aware, when we use cost-based methods or profit-based methods, we have to carry out a comparable search to identify to determine the arm's length price. When we talk about intangibles, it's really difficult to find comparable transaction or comparable price having the exact nature of what we are discussing. Because intangibles, there is no, intangible is a very broad, so, and they are very unique in nature. So getting the right set of comparables is really, at least they're not available on a public domain. So the challenge with either with the MNCs or the tax authority is how to find out the comparables or how to find out the comparable transaction. So that is the biggest challenge here. So then so you want to add something?
Yeah. So here, this is the most important question in entire transfer pricing. Because transfer pricing, if you look at what is that, transfer pricing is comparing a price in a controlled situation with an uncontrolled situation, isn't it? So whenever the moment you talk about this, there are 2 things which become very important. One is the transaction and the other one is entity. And this is where the confusion starts happening in the mind of many people. They forget transaction and they concentrate on the entity. we have to, and when we talk about the transfer pricing of intangible, the transaction is very, very important. What I mean to say is that, in case of a development of, in the Dempsey function, as we have seen, it is, if we cannot get exact comparable, if we can get exact comparable, cup is there. If it is possible to split the profit split method is there. But when we find that there is no such thing which is coming out, how to go forward on this? My take on this is that we start analyzing the 5 transactions. That is the development, maintenance, all those 5, enhancement, protection, all those 5. And it is possible that if some entity is undertaking 1 or 2 or 3 or 4, depending upon that, can we find out a function in an uncontrolled situation? So once you start doing that, it is possible that you will be able to compute. You are able to find out the arm's length principle. I am reminded of a very interesting story coming from Mahabharata. Is that Arjun had one Naulakha har, necklace made of 9 stones. And the beauty of that, necklace was that if you look into one, you can see all 9. So transfer pricing is basically, that at the end of the day, when you look at one, you should have a clear understanding of the other things. If you are able to get it, fine, you can do it. But if you're not able to even do all those things, then you have to go to the other method, which is the valuation method. And there, DCF method or whatever method, many countries are adopting DCF as the most appropriate method. So you need to go for that. The moment you go for that, there are many minds, which you have to take into account. Any assumption, or any parameter which you build into the DCF method, a minor change in that will make a huge change in the valuation. So one need to look at that both when the transaction is being negotiated, and second, when the transaction is being justified. When you are justifying, the authority or you have better understanding, but when you are planning, then what are the assumptions you are making becomes very, very important. You need to document in a great detail all the assumptions, all the parameters which you are using for the purpose of valuation. Yes, Mohan.
Sir, I have a question here. So like you just mentioned, so the thing is, when we talk about, let's say if I'm getting assessment done, so when you talk about valuation, when the asset is new, it's in a developing phase, and it's partially built, and I have to transfer that asset. So I'll be using DCF. That time I'm working on discounted cash flows or projections, based on projections. But in 3 or 4 years, when I have everything up and running, and when the assessment cycle comes up, they have the actual numbers at that time. So
this is what I said. This is what basically I said. That, when the assessment is taken after 3 years, you need to justify why you took a particular assumption. The tax authorities are very much aware that the things can change. But they would like to fully understand that when you made those assumptions, what was the underlying facts or what was the underlying assumptions for that? That has to be brought out, and that is why I said a proper documentation of all these things need to be maintained by you whenever the valuation is done.
Sir, I have just one doubt here. From a practical perspective, I believe for these intangibles, we cannot get any data of CUP. There is no database available which provide us the information which is on a transaction level. So for example, so there are 2 companies, both are developing, let's say, an intangible, maybe software, maybe other things. One is being done by a group entity, another have hired an independent person to do that. So the price that they have been assuming, other things being constant, the type of software is same, the quality of software is solved. So let's take one example as Ola and Uber. So both are making an app. Uber used their group entity to develop that app. Ola used an independent person to develop the app. Both are doing the same thing, exactly similar function. But the data of how much the owner of the Ola brand or the company owns this Ola have paid to an independent party is not generally available in the public domain. So I believe that CUP in the Indian context will never be available. The data is not available in the public domain, so hence it is not acceptable or applicable. Now, then if it is not, then move to the next step. So whether DCF is the only solution. So if it is the only solution, then in most of my experience, whether it is Indian tax authorities, and I have some experience of foreign tax authorities also, so they always tries to benchmark our assumptions that we took 1 year, 2 year, or 3 year, in many countries 4 years ago with the actual numbers. So if the actual numbers are higher than what we projected, then they simply say that you have undervalued it. If it is lower than what we projected, then they said you have undervalued it. So I personally believe that even DCF is being undertaken. So that is also not a foolproof solution. What is acceptable to the revenue of various countries. I'm not only naming India, but as across the globe. So if in such a scenarios, so should you feel that profit split or residual profit split method, which is generally being used in India, is the only solution available for these kinds of intangibles?
You resort to the other method, that is the the valuation method, when all your 5 methods fail. So when the profit split method fail, only there you go, not the reverse way. If your profit split method or residual profit split method can, help you in determining the arm's length price, there is no need to go to the, the 6th method or the valuation method.
So you are saying that if profit split is available and it is applicable, we should stick to profit split. And if it is not applicable, then only we should go for DCF. So that is
my view. That's my view. I'm open to suggestion.
So GC sir, any comments on this particular part?
As far as this part is concerned, using a particular method, yes, it will depend on the facts of that case. But I agree with this, that if there is one prescribed method is available, then residual or any other method would certainly should come after these fail. That's the better principle. But more on that, one thing which has bothered me always, this item 1 and 6, and that the whole purpose of the transfer pricing is to remove the aberrations that creep in because of the relationship among the enterprises, group companies. Now, particularly in respect of R&D functions, it is difficult to assume, very difficult, that any entity would like to assign its R&D function on a contract basis to a third party. So R&D is something which is very close to the heart of any group, any entity, and to the very assumption that there can be a contract R&D in uncontrolled situation. It's very difficult to believe. Or in practice, yes, there may be certain areas, as you Avinash pointed out, that yes, Ola and Uber's case, yes, it can be. It's something harmless kind of R&D, or but there could be a research development which is very, very unique and developing into unique intangibles. So in that case, it's very difficult to bring in uncontrolled situation, because it can never happen in an uncontrolled situation. So that is really answer to that is, we will not find any comparables. We will not get any comparables in uncontrolled situations, particularly for those unique intangibles. And that's why when we go to profit split method, it talks of unique intangibles.
Yeah, Mohit.
So the point number 3 talks about the ownership. Or are you the actual owner, or you are just using the intangible? Let's say, for example, brand. So someone has created a brand and someone is the real owner of brand. If I talk about Walmart or any Apple, so there could be a possibility that they've been registered with one of the jurisdictions. But let's say if there is a distributor or manufacturer in India and using that brand, okay, and if they are spending to promote sales within the jurisdiction in India, whether that would be called enhancing that brand, that the spend of business and promotion would be treated as whether they are increasing the brand value or not. So all these challenges are really faced by the MNC groups or when they talk about intangibles. So the third point would be difficulty in isolation of impact of any particular intangible on the MNC group's income. So there could be a possibility that in there could be multiple associated enterprises, and lot many times really get difficult to really identify which is contributing what. So for this, there are challenges faced. How to really do that. The key aspect here is functional analysis. How robust is our documentation when it comes to determining the income made by the M&E groups. The 5th point talks about contribution.
So here, Mohit, this is number 4 is basically the reason why TNMM cannot be applied for the purpose of determining, arm's length price of a transaction in intangible, because it is next to impossible to actually identify. There is one very interesting case. Where I was involved, and in fact, I took guidance from GC sir also. Is that what is the difference between one company developing its own intangible and the other buying intangible from someone else? Will it make any impact on the profitability? That was the question. We could get hold of some analysis by economists in universities, and which has because there was no concrete answer in respect of that. Because when you buy, you spend. When you develop, you spend. So how is it going to impact is very, very difficult. It's very difficult.
I think, sir, with this, I just want to make one comment here on this particular part. Sir, if you see the OECD commentary or the UN commentary on this, so when they are saying that what is an intangible or why there is an intangible, so they say that intangible is something which gives you certain profit, which is over and above the normal profits. So without intangible, if you are getting an X amount of profit, with intangible, it has to be X plus. So that is something what OECD and UN said. So though I slightly disagree with this also, but this is what it is written there. So when you are saying whether I am myself is developing an intangible vis-a-vis I am buying an intangible, or not buying, let's say I am licensing it from somebody else. So in both the cases, I believe my intangible exists. And because of these intangibles, I am getting some amount of profit, which is over and above the normal thing. So for me, and to my limited understanding and knowledge, whether it is developed by me or I have licensed it from somewhere, there is a value which is attached to both of them. And we should, while distributing or splitting the profit amongst the entity, we should give the due care of the same in those cases. So that is my limited answer to what you said. And I may be wrong. I'm not saying that I am right, but this is what I understand, sir.
In taxation, there is no right or wrong. So it's only views which are there. I agree with you, Avinash. When there is only one intangible, yes, I totally agree. But when there are multiple intangibles, then it becomes very difficult to identify what is the the contribution to profit by a particular intangible.
Okay. So the point number 5 talks about contributions and actual realization taking place in different years. So there could be a possibility that you are making investment on day one, but there is no guarantee that it's going to be fruitful in the year 3 or 4. Not many times it happens when you are making a formulation of some drugs. So you make investments, or you do funding, or you gather resources to prepare that formula. But there are at certain times chances that you may not be getting approvals from the concerned departments. So this particular aspect is also one of the major challenges when we talk about intangibles.
I think that it is very important question here. So, for example, there is a company A who sponsors a Cricket World Cup or a FIFA World Cup, which is going to happen in some days, and then they demarcated, okay, out of the total sponsorship to be made for sponsoring that worldwide event. So the contribution is being divided among the group based on maybe turnover, based on maybe the profitability, but we cannot estimate that how much is the realization. So for example, there is a company A who sponsored 100 crores to an international event, and they allocated 10 crores to an Indian entity. Okay, for out of the total sponsorship, the 10 crores is being contributed by India. So as an Indian entity, as a transfer pricing person of this entity, I cannot estimate that by sponsoring that event and by contributing that 10 crores, how much is the realized value, whether I am able to get more than 10 crores out of it or less than 10 crores out of it. But yes, the fact is that we have contributed maybe based on the turnovers of the entities at various groups. Some also say that the profitability is also a basis of bifurcating. And in one of the case, I found that one company has sponsored this event and distributed only in 5 entities of the group. They are having about 20 entities in the group, but they said my functional entities are only 5, so I am dividing it into 5. So how as a normal practitioner in India, I should take care of this particular transaction. So how I should do it? So that's a big question that I think is there in the mind of our viewers also. So what to do in those cases, sir?
You want me to answer?
You or GC sir, both. Okay. I know there is no standard answer to it, but yes, many times it is there in the minds of all of us.
The first thing which I would like to underline is that, when you incur an expense, you do not know what profit it's going to get you. It may get you profit, it may not get you any profit. At the end of the day, before you invested, made the investment, suppose your sale was 100 crores. It is not necessary that if the cost of 10 crore is allocated to you, your the turnover is going to increase by 20 crore and make it 120 crore. It may happen, it may not happen. So that is the big challenge, particularly in respect of intangible, and that is what we say about hard to value intangible. Because if something is the result is going to come in long years, it becomes very difficult to value it. In retrospect, after 5 years, if the assessment is undertaken, by that time one would know whether there has been any profit or not. But when you are investing, how are you investing? What is a legitimate way of doing this? If we can lay our hands on similar things, what has happened, then we can always justify before the tax authorities that, look here, this was my underlying assumption when I accepted distribution of 10 crore. Because, when the group takes a decision, whether it simply, allocates it or takes my view, will become very, very important. Because if it takes my view, I can always say that this is the computation how I thought that out of 100 crore, 10 crore expense may be allocated to me, because I am likely to gain, more than 10 crore. So that is the computation which we will have to produce before the tax authorities. But if you will ask me how it's going to be benchmarked, it's very, very difficult to do that. JC sir.
But Avinash, I was just wondering, in transfer pricing, we do the benchmarking of the transaction. So there can be two kinds of transactions in intangibles. One is when you get the use of that intangible, a right to use that intangible, and that has to be benchmarked. The other is when that intangible is transferred. And at that point of time, different entities, what should be their share in that profit or the receipt that they get on transfer. So yes, these contribution of these functions or risks would be very relevant to decide at the time of exit or at the time of transfer. But when some intangible is assigned or given for right to use is given or actual use is given to some entity in the group, then in that event, all that is needed is to assess whether the license fee charge is adequate or not, or it is arm's length or not, or the compensation that is being sought, or the fee that is being given. I mean, it depends on that. So in that could be on the basis of the actual value of the user, and that may not be necessarily dependent on the ultimate profit that the entity makes. May or may not be. So I think whether the impact of a particular IPR which it has on the final profits of the company, should that be a very relevant factor? I mean, I was just wondering.
Sir, what happens is in these transactions, so generally the parent company used to pay to the international company, and then they charge it as a reimbursement. So normally the transfer pricing officers at the time of assessments only, they will ask us that you have contributed this much amount for the event, but whether you have actually realized the profit, or why you are reimbursing only 10%, why not only 2%, or why not 15%? So that's something which have come in the real world when we talk about this particular aspects about the realization of the contribution.
So that means that reimbursement is not actually a reimbursement, but it is name given, but it represents some other consideration. If that be the case,
I think yes. I think this is what the M&E groups are doing it.
Yes, that's what they are doing. True. I mean, so then we have to go and really determine the price, compensation or price or whatever you call it, for that particular transaction for which the reimbursement is being made. If it is not in the character of reimbursement, actually, then all these factors will come into play. Yeah, certainly. I mean, for what? I mean, but again, there also, I still wonder whether the ultimate profit that the entity is making, should that be taken into account? Because that would not be a certain, and that may not be neither at the point when the transfer is made or the right to use is given, or when it is determined. I mean, it would be not should not be.
Avinash, I have a practical suggestion in these type of cases, and where we have been successful, in defending, is that, at the time when this transaction was taking place, the group headquarter was working on this. If it is push one, then becomes very difficult to defend. But if they give you opportunity to choose, and then you have, documented it and have put it in the exchange of mails, then it becomes possible to defend before the authorities.
I think probably benefit test, if that is being referred to, in
yes.
that,
yes, sir.
Then in that is only to demonstrate. To demonstrate that the asset was in use, actually in use, and not just a paper assertion. So that it only goes to suggest that much. So if asset was using, have you derived any benefit out of that? Yeah. So the question which benefit test poses is this one. If factually it could be demonstrated otherwise, then I don't think benefit test is at all needed.
So here, Avinash, we'll have to move away from accounting concept and go into, as sir said just now, the cost benefit analysis. If we can undertake that, we have a report in hand, then that will be something which we can share with the authorities at the time of the assessment.
I agree. So I have a live case where one of my client has sponsored only Asia Cup. And he have come back to me as a transfer pricing consultant to tell them that how the entire money sponsored by them should be allocated to their various entities who are there in the Asia. So then I asked them, so who is the actual owner of this brand? So they said the brand owner is situated in country A outside India. So I just asked them whether the brand owner is not benefited out of it. Answer is yes. Maybe in Asia Cup, the teams only from Asia is playing, but it is being watched everywhere. So these are very difficult questions which have been posed by the clients to us. And as an transfer pricing consultant, or now in the shoes of a transfer pricing auditor, because we have to file this 3CB. So these actual realization part, what is being mentioned here in the slide also. So this is really becoming very difficult for anybody to answer.
So, I mean, yes, for example, that you said that the sponsorship, I mean, these cases have come, I think, in here also in quite a few cases where the sponsors which charges for cricket matches were paid, I mean, for example, I mean, which were not held in India, held outside India, even for that. So could be, I mean, whether it increases the viewership in India or not, whether the subscription revenue or ad revenues of those channel owners really go up or not. I mean, that may go up in fact, it may not. I mean, so then the question is, I mean, whether one would wait. I mean, the allocation would wait till the viewership is assessed. I mean, it's a question of whether that is a function which necessitates, I mean, for the development or enhancement of their business activity or of their revenues, which whether that should be done or not. That is a question. And if it is done, it's for a business consideration, then all that needs to be determined is at what price, and then what could be the share of allocation. And share of allocation between different countries where the footprint of that telecast is, I mean, that can depend on whatever existing factors are. But to take future factors into account for allocating those expenses would be a difficult question to answer.
Thank you, sir.
Thank you, sir. So these are the few challenges which are usually faced by undertaking DEMP analysis. Let me go ahead and start. So we are running short of time. So let us take these. These are relatively easier concepts. So let me just pass through them. I'll just give you the gist. What are available in these slides? So this particular slide talks about what should be considered when we are preparing local files or master files of these MNCs. So one is we know the basis, the PAR analysis, what we call the business profile, the business rationale that needs to be documented in the local files. Why we are carrying out a particular, what is the business rationale behind it? What are the future? So in case of intangibles, it's very useful if you document about how are we planning to have those future economic benefits from this relevant transactions. So these are the few points which need to be mentioned. We can talk about selection of the most appropriate method, selecting the tested party, identifying the comparables. All these things needs to be documented in the transfer pricing report. I think we can skip this. These are the key factors to determine. So when we are determining the arm's length price in case of intangibles, these are a few parameters which we should keep in mind when we are valuing intangibles. One would be exclusivity. So there are instances when the A gives exclusive, non-exclusive right. For example, there could be a situation when the Indian entity get right to use intangible only for a particular period, or let's say for a like they can use the intangible for a limited geographical region, like only for India, Nepal, and Bhutan, not for other Asian countries. You cannot use those products or anything like that in other jurisdictions. So I've covered useful. So there is a possibility that the intangible we are talking about, it has a shelf life. So when we are determining arm's length price, we need to consider what is the useful life of the assets we are talking about. Stage of development is a very important aspect because intangibles, they have the entire value chain. If we talk about, let's say, software or a formulation for the pharma companies, so there is an entire phase of development, coding, or stuff, and trials, prototypes, approvals, and all these things need to be considered when we are determining the arm's length price. Right to enhancement, revision, and update. Of course, we have covered this earlier also. This is one of the most important. Then the expectation of future benefits. How are we benefiting from all these intangibles? That needs to be documented. Okay, I think we can skip this. We have already discussed this. This is an interesting part, sir. SP Singh sir have just mentioned about the valuation techniques when we were talking about how to value intangibles. So this is an interesting topic. So there are many valuation techniques available: income approach, cost approach, replacement approaches. So the most prominent one is the discounted cash flows, where we talk about future economic benefits and we discount them based on the discount rates and all. So these are the few parameters which needs to be considered when we are determining when we are using the valuation techniques. I know I'm going a little faster because we have a lot to cover. We have some interesting case studies also. I don't know how many we can take up.
Well, don't worry, we have enough time, so you can take time.
Okay. I think, Avinash, from this being your one of the most favorite topics, why don't you?
I think this is one of the first of its kind clear-cut guidelines being given by CBDT, and this is really very, very interesting circular which have been issued way back in 2013. But this is applicable even till date, and these are phenomenal guidelines which have been given in this circular. So what this circular is all about, this is basically how to benchmark the R&D. So this R&D is one function which is extensively being done in India, and there are many R&D centers which are located in India, which belongs to the foreign M&E groups. So what happened at that time, the board have classified this R&D function into three categories. So they said that there would be or there might be three kinds of R&D functions being done in the country. One is the R&D with entrepreneurial risk. So there is an R&D which is being done where entire risk is being associated with the Indian entity itself. So they are doing it. So as earlier also mentioned in the presentation and in the discussion, that okay, the Indian company is given a task, okay, you need to design something. But how you will design, how you will develop, this is entire risk is given to an Indian entity, and they have to do it. Foreign entity or the part of the AE have no control, nothing except to fund that particular R&D. So that's then called as an R&D with entrepreneurial risk. The second R&D function, which is rarely find it in India, is a cost sharing arrangement. Okay, part of the cost is being financed by the AE group, AE entity outside India, and part of the same is being funded by the Indian entity, or maybe two entities are sharing the entire cost of R&D. They might also be having some kind of a joint controls which is being there on this R&D function. And the third, which is normally we found in India, or I cannot say normally, but in my experience, what I found was a low risk R&D center where the foreign party, the foreign AE is only compensating me. They are controlling my actions. On his behalf, I am doing it after their approval. And entire reward of this R&D is also being taken care by the foreign AE itself. So they classified these R&Ds into three categories. So for first two categories, that is the category of what we say entrepreneurial R&D and a joint cost sharing R&Ds, they said that normally the profit split method or any other method should be applied. But for a low risk R&D center, they have mentioned here that TNMM or cost plus whatever we say may be used. So they have not said it is to be used, but they said it may be used. And then they defined what is the meaning of low risk R&D. Mohit, if you can move to next slide. So they have said that if the Indian Development Center, which is an Indian entity which is doing it, if they are doing all the work on behalf of the foreign entity or a foreign AE, providing all kind of services under the direct strategic framework provided by the foreign entity. The foreign entity is providing the funds. They are giving all kind of economic support, financial support. They are also watching. They are also working under the direct supervision. They are monitoring the activity on the regular basis. They are actually controlling and supervising the research. Well, can we move to the next slide? So these are the parameters what needs to be fulfilled to be classified R&D to be a low risk R&D. Then they said there is no economic, there is the Indian entity do not assumes any kind of economic risk. So entire economic risk is being funded and substantiated by or borne by the foreign entity itself. If this is the case, and this is the last fifth one is also very important. Fifth point is that the foreign entity is not being located into a tax haven. So that is also very important condition that they are put in. So that foreign entity who is funding is not a Cayman Island company or earlier the Cyprus, which is being enlisted under 94A of the Act, or any territory which have been notified for that purpose. And Indian R&D Center is not owning any part of the research or development what they have made out of this entire exercise. Then yes, we can classify it as a low risk R&D, and that the same can be benchmarked either on a TNMM basis or a cost plus basis. So this is one guidance which is available. So in nutshell, we say entity in India who is performing the research or development part on behalf of the foreign entity, entirely funded by the foreign entity, under the direct supervision, control, and monitoring of the foreign party or foreign entity, under the framework and instructions given by the foreign party, having no economic risk assumed for that development, and do not have any kind of an ownership on the outcome of the project what is there, and the foreign party which is not located in the tax havens which is being notified under 94A or any of the chapter 10 of the Act, then it is classified to be a low risk R&D center and can be benchmarked under the TNM. It's a beautiful guidance in many of the cases where we are developing softwares here, where we are doing R&D here, where we are creating some kind of a product designs, etc. here. Even if in many cases where we are providing some kind of an intangible services here. So if we classify and fulfills all the conditions, not only on the contract, but in conduct, in actual basis also, what Varshney sir have mentioned, that's the basic purpose of DEPS Action Plan 8, that it is not merely on papers, but in reality also these conditions are being satisfied, then yes, it can be classified as a low risk R&D, and the same can be benchmarked on either TNM or cost plus basis. So that is what this circular 6 of 2018 talks about. Over to Mohit, and any comments from the experts on this, sir?
And just one, I'll put great emphasis on your last point that you made, that it should be evident from the contractual as also the conduct of the parties. That's a very important aspect.
Yes, Mohit. Mohit, over to you for the next slide.
I think we can now start with the case studies. This is the most interesting part of the entire session, I would say. Now we have the context. Now we know what is DEMPE, what are intangibles, what are the challenges faced, how the 6 steps which we have discussed earlier. So all these things are going to be useful while solving these case studies. Guys, let's make this very interactive, sir. SP Singh sir, GC sir, Avinash, you can pitch in whenever you want. Okay, so the situation one here is P is a parent company, S is a wholly owned subsidiary of a PP. So these are the facts which are mentioned on the right hand side of the slide. So I will just read out for the larger audience. P funds R&D and perform ongoing R&D activities. S does not conduct or control any of the R&D activities. It has no technical person. It does not incur any R&D expenses. As a policy, all rights of IP are assigned to S to centralize and simplify the global patent administration. Okay. S pays nominal fee to P for assignment of rights. S grants to P an exclusive royalty-free patent license with right to sublicense for full life of IP. So the basic idea here is P is a parent company who is funding the R&D operations. S is making some payments for assignment of IP rights, and P is not charging any royalty for these services. So can you identify which company is performing which functions? So we just discussed DEMPE. So development, which out of these two companies, P and S, P is being parent and S being subsidiary, which entity of the M&E group is performing development function, enhancement function, maintenance function, protection function, and which entity is exploiting the entire thing?
I think Mohit, answer is there on this
slide. I know. But I just thought to just give them a little bit of
the most important thing, which is mentioned here, the functions, the employee strength of the two organizations. That determines, why a particular activity has been assigned to a particular company. Yes. And that is the core of the discussion of what just now, Avinash has taken us through. The circular, when he talked about, these are the things which are highlighted in this circular.
Yeah, I think, sir, here if we see, because development is being done by parent only, so the first function is with the parent only. And because they are also doing the entire development, I believe enhancement is also being done by them only.
Yes.
So that's why the first two circles here put it very clearly on the parent part. And for the next MNP, if we see, so these are being funded by the WOS, that is wholly owned subsidiary S. So that's why these functions are being done here. And exploitation is being done by parent because parent is earning royalty. So that's why the exploitation is realized by the parent only. So Mohit, am I correct? That's why you put it there?
Yes, bang on. Yes.
So there will be one situation, suppose S exploits it because S is a subsidiary. Then in that case, when we'll talk about the compensation to S, this DEMPE function will come into existence. Because for whatever the functions being done by S, suppose, $100 worth of, royalty is earned. Then out of 100, what should go to S and what should go to P will be the question. So what S would be keeping, and out of that, what it will be paying to P, there is, the whole TP analysis. And that is what I mentioned, that when we are talking about identifying the compensation, these are the functions which we need to take, that for development, what is the comparable which we'll be doing. And here S is doing certain activities. If E comes within S, a part of E comes within S, then for 3 activities, how it should be compensated, we can look for a comparable and then find the compensation to S. Yes, Mohit.
So I think we can go to the situation 2, because you'll see how when we're talking about DEMPE analysis, how it is going to shift from P to S as we proceed the case study. So that's the beauty of these case study. So I'll shift to situation 2. So in situation 2, the facts of situation 1 remain same. The only difference is, instead of S granting exclusive royalty-free patent license with right to sublicense for full life of IP to P, S, under the control and directions of P, sublicense it to A's and third parties. So here he's just so S does not have the exclusive rights. He is sublicensing it to A's and third parties. So if you'll see in case number 1 and in case number 2, the only difference is exploitation. Now the S is also getting benefit of these intangibles, since he has said he has licensed it to the other A's and third parties. Are you with me?
So here,
yes,
it is possible to invoke, the cup method, because S is giving license to AE as well as to the third party.
Yes.
So possibility of bringing in cup will be there for identifying, because for other activities P has to be compensated.
Yes. So can I move ahead?
Yeah.
So in situation 3, the other facts remain same. The only difference is, instead of licensing the rights of IP to AE and third parties, S sell IP to third parties under direction and control of P. The increase in price of IP is attributable to the period when S was a legal owner. So this here, what he has done is the AE has gone. Now there is only third party customer, and now he has sold that IP to the third party customer.
Is it an outright sale that he have made?
Of course, under the supervision of P. So P has guided him. Okay, you sell it, and under the directions of P, that okay, you can sell it to third parties.
So I think the act of selling is being done by S. So S is also exploiting it.
No, but the thing is, the particular question here is, S is doing functions on the instructions of P. So is he acting as a agent? S has the control over the IP. The pertinent question here is that. So it's still with P, because the thing is, the IP is still controlled by P. S is doing all these functions on the directions of P. So that is the reason the exploitation still remains with P.
Okay.
Okay. Now in situation 4, so the beauty of this case is all other functions are going to be performed by S, only the development would remain with P. So here S has employed employees who make the decision to take on the patent portfolio and takes all the decisions relating to licensing program, negotiating with licensees, and monitoring compliance of third parties with the term of licensees. S license the IP to third party and thereafter sell it to another third party at a price far exceeding the price paid by S to P for original purchase, as the value of the patent has increased due to external unforeseen circumstances. S make all decisions regarding sales. It manages and controls the distribution of the patents. So now what has happened is P has only developed, the parent company has only developed the intangible, but rest of the things, the S has got the supervision, S has got the control over the assets. They have the employees who are taking decisions, and S has sold the intangible to third parties. The exploitation has shifted from P to S. So what is happening in these case studies is we are stripping off different functions from P and we are passing it on to S.
So meaning thereby only the original product is being developed by P.
Yes.
And the entire other functions is being done by S.
Yes.
So that's why the share of the selling should also come to S. That's why you're saying that exploiting is also being done by S.
Yes. So we talked about 5 things which are covered under DEMPE. One is development. So if you see, only P has done, in this particular case, P has done only development. That was done initially by him. Now rest of the functions are being performed by S. He has control, he's interacting with third parties, he's sub-licensing it to them, or he's selling it to them. He has employees who can directly control the transactions or who are involved in decision making. So the key, the 3 criteria here is decision making. Who is involved in decision making? So if you see from P, the shift from P to S. So if I talk about the value creation in each step, so it has been stripped off from P and been handed over to S. So ideally, the remuneration also, if I talk about the entire pie, the remuneration should be such. Now S should be rewarded handsomely and P should be left with routine returns. Excuse me. So any, do you want to add something or should I proceed?
Yeah, please proceed.
Now, this is situation 5, where everything has been shifted to S. So I'll read it out for you. P&S decides to develop an intangible. Now we have categorized what are the functions performed by P here and what are the functions performed by S. So funds, like Sir has mentioned initially, funds R&D and will be the legal owner of IP. So it doesn't matter, even if you're funding the entire R&D research work or the entire thing, it doesn't matter till the time you don't take the key decisions. So this particular example talks about that. Contractually assumes and has the capacity to assume financial risk and exercise control over the financial risk. He is just having only one risk, that is financial risk. But he has the capacity to undertake that. So this is the only key function which is being performed by parent company now. He's just funding the entire R&D process. Now, what are the functions performed by S? S has existing IP which will benefit the R&D function. It has a track record and experienced employees. Performs and control all R&D functions. Key decisions maker regarding development of IP is all done by S. P is just funding the entire thing, but all other major functions, employees, experienced employees, control over the functions is all lies with S. So in this particular case, P should be remunerated based on routine returns, but the entire exploitation, the entire 5 functions is shifted to S. I hope this has made you clear what DEMPE analysis is. So anyone who want to?
No, it's very clear.
Very clear?
Go ahead.
It's very clear.
So this particular thing, the recent issues in intangibles, which has already been touched upon. But sir, any remarks on this?
In fact, one of the questions which have been put in many conferences is, what is the meaning of hard to value intangibles? Because at times, people confuse between unable to find a comparable and hard to value intangibles. There is a basic difference between the two. And that difference, hard to value intangibles is in fact, is the one which I just talked about, that where no reliable comparable exists, no doubt. And second, at the time the transaction was entered into, the projection of future cash flow or income expected to be derived from the transferred intangibles or the assumptions used in valuing the intangible are highly uncertain. So, when we were discussing which method to apply, we divided into 2 categories. And one was where we can apply the accepted 5 methods. The other was that when 5 methods fail, then we go to the valuation method. Here we are talking about a situation where 5 fail, and also so far as the other method is concerned, there is uncertainty about it. And that makes, those intangibles hard to value intangibles. And there are certain characteristics, particularly, the intangible which is half developed. That becomes, really very difficult. A transaction happens with not a fully developed intangible, but half developed. What the extent, it has been developed, those are the characteristics which make a particular intangible a hard to value intangible. Now, second is the AMP, because in India, we have come across, many cases, and now it is before the Supreme Court, so far as the issues are concerned. And JC sir has appeared in many of them. He has hands-on experience. So I will request him to talk about these 2, AMP and software. And then I along with him, will discuss the last item.
See, the AMP, these were number of cases when came along. The lead case, of course, was before a special bench in the LG's case. Point was that this in India, the real core issues behind AMP were really lost in the mire of that one legal issue raised whether it is an international transaction or not. In fact, that was not the core issue. I mean, yes, but as the lawyers make it and the counsels do it, I mean, so they found it easier. So that was it got diverted in that direction, that no, whether or not it is an international transaction. If you were to see the first round of Delhi High Court, which was authored by Justice Sanjeev Khanna, there he said very categorically that I'm not going into this question at all, whether it is international. It is an international transaction. Where is the issue in that? Then the issue that he raised up, and those were the right core issues, were whether in a distribution function, whether the development of the market is an integral function of the distribution, or it is a segregated function. Whether you can have separate ALP for distribution function and another ALP for the development function, market development function. He said integrated approach can also be taken. It depends on the material available before. But later on, a batch of appeals in the Delhi High Court, they said, no, it is not an international transaction at all. And therefore, did not go into that question. And both the issues are now lying before the Honorable Supreme Court. The question in MP is, it was the adequacy of the compensation that was being given to the distributors in India, and whether it was with or without development of the market. I mean, that was a question. So some contractual arrangements were there, where the contract is very clearly specified that yes, you have also to do the advertising functions or marketing functions. Some did not, but in practice, in actual conduct, the companies did that. They were doing marketing functions also. If you go internationally, and then we had made some research to find out the international agreements from the databases available elsewhere, you will find that the compensation for distribution function or the royalty for the use of the trademark, that would depend on whether the marketing activities go with it or not. For example, there are agreements internationally which say that if you are doing marketing also, yes, you may pay less royalty, or you may get higher compensation as a discount in the supply of goods or services. So either way you are compensated. But if you are not doing that function, then you are giving it lower compensation. So that's a very, very simple, accepted approach. I don't know, why so much of controversy is developed here. And at one stage, some of these companies, they had distributors in other countries in the Asia region and subsidiaries in India. Now, so in one of the cases, I found, while arguing the matter, that they had a third-party agent in Pakistan and a subsidiary in India. So next day, when I went to the court, I pointed them out, look here, the market conditions between Amritsar and Lahore are same. There is no change. There is only one Bagha border in between the two. So, now if revenue would be satisfied if they pay the same compensation as they pay to a third party in Pakistan. Yes, the bench said yes, that's a good idea, good suggestion. But we cannot do that. Your tax, the assessing officer had to go into that exercise. That's a different matter. But the point is that whether you value it as an integrated function, development of the market, along with the distribution function or franchisee or other things, whatever be, or you value them independently. The question is, it's a question of adequacy of compensation, which is the whole basis, the heart of the transfer fighting analysis, and not the question whether it is an international transaction or not international transaction. Any transaction which you enter with the AE I mean, obviously it is an international transaction, and the amendments have now had to be made in 2012, and they have been made now part of it. So as far as EMP is concerned, we'll have to wait, but I do not think that there can be any doubt on that aspect, that if any intangible is being developed and the cost is being borne by the Indian entity without being, with a compensation is for the distribution function. But if that some in the process, some intangible, say marketing intangible is being developed, then Indian entities, if bearing the cost and making its efforts, then it ought to get compensation at the time of transfer of that intangible. Right? So that is the question which really begs an answer in those cases, because ultimately what will happen, say for example, an Indian subsidiary is working here. Now Indian subsidiary, I mean, it functions, it's all right. It is filing its return of income and paying taxes here. But 6 months hereafter, the parent decides to close down that subsidiary and assign that function to a third-party distributor. So the entire market which has been developed goes to that person. And he then settles on a different issue. So should Indian company, which has spent for those many years on the development of that market, should it not have its share in the profits where it is realized on the sale of that asset, intangible? That is the core question to my mind in that. And yes, on a regular basis, day-to-day basis, how that is to be determined, the distribution or marketing functions. That was as far as EMP was concerned. I mean, anything else you want in a short time, this is all. But otherwise, there is a lot to EMP is something which we can talk about. But core issues are this. Anything on this, or we proceed to?
Proceed, sir.
On software, yes, it has now been settled by Supreme Court by decision in engineering analysis. Now, software, the question is that is classified, what is the basis of the Supreme Court's decision? Supreme Court says that software is classified as a literary work under the Indian Copyright Act. And what are the rights under the Copyright Act of the author or of the developer of the software? Those are right of duplication, and right of adaptation, and right of all those things. So now, unless the right of duplication is there, reproduction is there cannot be any element of royalty in that. But the question is, now the larger question which was not examined by the Supreme Court and not raised before it, is the question is this: where is that right of reproduction exercised? That is very interesting. Now, Indian Copyright Act says that if you make a single copy, right, for your use or for archival purposes, then it is not a violation of Copyright Act. So that means one copy you can make without violating the Copyright Act. Correct. Now here in all these cases, no right of duplication was given. Only the software was licensed for use. So right to use was given, but right of duplication was not there. But the question is, there are different kinds of CDs. I mean, if you see, if I use a music CD, for example, or a video, if I use that CD and I put it in my laptop or the computer, I watch the music, close it, take out the CD, my laptop or hard disk is not affected, not at all affected. But when I use a system software or an application software, then that has necessarily to be, a copy has to be made in my system. Otherwise, it won't work. So one copy is made. Now, whether that one copy is made under authority of the copyright owner or that one copy is made on my own volition and I'm not violating section 50 by section 52. So non-violation of Copyright Act is one thing, and grant of making one copy by the author is another thing. So right of the author does not affect the right of the customer. Right of customer is different, but here the customer is making one copy under the right given by the author. So the licensor does give right of making one copy. Whether that is good enough to make that issue, yes, there is a right of reproduction. Second aspect was that there is a Ministry of Information guidelines where they say, one of the guidelines very clearly states that even one single copy, if it is made, it does, I mean, without the authority, I mean, it's a exercise of the duplication right. But I'm not going into these technicalities. The question is this, that it's actual conduct. What you find, certain materializations, if you find that if I am holding a software, for example, a software, and I am using it. But suppose if the claim is that it is sold, not transferred. That's it is licensed, not sold. So if it is that is EULA. So if it is licensed, not sold, then some right is being given. And that right was being taxed by the revenue. But yes, of course, now Supreme Court has finally held that yes, I don't know whether review petition is still pending or not, but that apart. What it says that no, unless the right of duplication is there, I mean, that right is not exercised. So therefore, that closes the issue for the time being. That's about, I mean, in short, it is there.
So the other item, I mean, which is going to attract the attention in future is the characterization issue, particularly between royalty, FTS, and business. There is one question, somebody has asked me a question, is that, if the expenses on technical services, if they are amortized, what will be the treatment? I mean, so this is going to be, I mean, suppose software is developed or anything is developed, any intangible is developed, not necessarily software, any intangible is developed on certain, the directions given by an entity. So based upon that, it keeps on to and fro, and then ultimately, something emerges. Now, the thing...
Please go ahead.
The thing which emerges, then is it intangible or is it a product of the service? That's going to attract the attention, because with the internet being so powerful, there is no need for in one go, because so far as FTS is concerned, the treatment may be different under the tax law as well as in the DTA. And particularly with different countries. So this royalty or FTS, the treaty shopping is one which can be undertaken to avoid either of those circumstances. And so far as business is concerned, I mean, generating or innovating as intangible, selling that can be a business. It can be a capital asset in the hands of the purchaser. It can be a revenue item in the hands of the purchaser, and it can have a different characteristic in the hand of the seller. So these are the questions whenever any transaction in any intangible is undertaken. One need to go into these minute details, because these are the things which are going to capture the mind of all the stakeholders in the years to come.
Yeah. So first, I think what strikes right now is the very critical aspect, a distinction between the royalty and FTS part. I mean, that's a very, very critical area. And what happens, I mean, where now there can be a situation, I mean, practical situation that there is suppose an equipment through which some services can be given. Now I am the owner of the equipment. A customer comes to me and he asks me to give him a service that and I use that equipment, which is my own equipment, and I render the service, give that service product or service as service. I mean, to him, it's a rendering of service, FTS, nothing else, right? So here there is a demand from the customer for rendering a certain service, which I perform on my own, whether through the use of the personnel or through the use of some equipment, and I do it on my own and render that service. That's it. But suppose he comes and he is wanting the same service, and this time my arrangement is that, look here, I give you my equipment for 4 hours. You use this equipment and get the service that you want. This equipment will be. Then what I am giving it? I am giving the right to use that equipment. Then it becomes a royalty. Maybe the end result may be the same. For the customer, end result may be the same. But in one, he is telling that this is what I want. You obtain the results and give the result to me. In the other, he is using the equipment or the infrastructure or the whatever it is to him, and so it can be some IPR or equipment using. So that is how the distinction can work. I mean, it's a crude example, but yes. And so that is it as far as the characterization between royalty and FTS, subject to so many treaty provisions, other complications we don't get into. As far as business is concerned, business can be a service, can be a business, rendering of service, right? One can also enter into a business of giving some tangible or intangible items on license. Licensing of these items can also be a business. So that is altogether different, and I don't think, because if it is into business, then royalty and FTS, either he is into the business of giving the things on license, or he is just providing license or the right to use of tangible or intangible to a third party and getting income out of that. That should be the basis for discussion, demarcation. And but that would be really, I mean, it's a particularly the characterization between royalty and FTS is raising lot many issues. Not many issues it has raised, and I think there are quite a number of cases pending in courts. I mean, we'll not like to put, but there are several issues on that. But business and royalty, I mean, very few. Any specific issue you have, so we can discuss on that.
So ultimately, I mean, I agree with what you were saying, sir, because these are the things which are, as the intangible spreads, and as the value contribution of intangible to the the total asset increases, these are the things which are going to come, and that is why
in future. Yeah, in future there will be far more chances of these characterization issues will come in much bigger way.
Much bigger.
These characterization issues and the valuation issues.
So understanding, yes, sir. So understanding intangible is very, very important.
Very important.
I hope, I mean, all the panelists, I mean, have contributed to increase your understanding in respect of intangible. Please keep studying. I mean, will you like to, Avinash, will you like to say something before we close it?
I think, sir, for the entire session, what I recollect and what I recognize, so intangibles is very hard to value, but still we can divide these intangible into two categories. One is the manufacturing intangibles, what we have, which talks about development activity, which talks about manufacturing activities and the R&Ds. And there is another set of issues which have come, and GC sir have enlightened all of us on marketing intangibles, specifically the AMP issues, the development of markets, the development of entire supply chain network, etc. So both are there, both are important. But as stated in the beginning by Kamlesh sir, in all these valuing intangibles, what is important is actual conduct of the business and who is bearing the financial risk, who is bearing the actual risk, and who is controlling the entire activities. This is what is important. Tempi function is one which is already people are using it and which is very, very important for valuing this intangibles. So as a closing remark, so I think this is one which we need to think. And as SP sir, you have already told in income tax, nothing is right, nothing is wrong. So similarly, in intangibles and benchmarking of intangible, everything is right and everything is wrong. So,
and everything is difficult to talk about.
Yes.
So thanks a lot, GC sir. I mean, for agreeing to grace this discussion. We are highly obliged, and thanks Mohit and Avinash for putting up such nice slide. I mean, Mohit had many sleepless nights before coming up, and the work which both of you have done in spite of the timelines. I'm sure soon after this is over, both of you will run and start looking at the services which you are providing to your customers, whether intangible or FTS. Doesn't matter. So it's again, and thanks to all the listeners. I mean, I'm really surprised. The panelists will be very happy to know that there has not been a single dropout. The number has simply increased so far as the listeners are concerned. That shows the amount or extent of interest which people have. Last but not the least, I mean, though Kamlesh is not here, thanks for his, the goodness in accepting our request and gracing this occasion and sharing his views. And lastly, I will like to thank the support team of ICI, Vikas and Dheeraj and all of them to work with us and to ensure that there is seamless webcasting of our. So thanks at the end of the day to everybody and wish you happy Diwali.
Thank you. Thank you very much.
Thank you. Thank you.
Recording stopped.
Yes. Thank you.
Thank you, Avinash. Thank you.